Hello everyone, it's Mark and welcome back. In this video I'm going to talk to you about the 3-day notice under Massachusetts Section 12 and also the Baker Act. So let me just again read you from the statute. I think this will help you to understand what's going on here, and also then we can talk about how this really works in reality. At any time during a conditional voluntary stay at the hospital, meaning you're there on a voluntary basis, you've agreed to stay there, and we could talk about why you wouldn't do that in another video, but at any time during a conditional voluntary stay at the hospital, an individual may submit a written notice to the hospital of intent to leave. This notice is called a 3-day notice. During these 3 days, the individual may be held at the hospital while the staff evaluates the person's clinical progress and suitability for discharge. A person may not be held against his or her will for longer than 3 days unless, prior to the end of the 3rd day, the hospital petitions for your commitment. Saturdays, Sundays, and legal holidays are excluded from the computation of the 3 days. An individual may retract the 3-day notice at any time before action is taken on it. No particular form is needed to do so. In practice, facilities often try to persuade people to cancel. Okay, so what are we talking about here? Well, in both Section 12 and the Baker Act, you can be held on a voluntary basis, meaning you have agreed to stay. And we could talk about why you would do that. We could talk about the pitfalls and how you might be coerced to agree to stay on a voluntary basis. But the fact of the matter is, you're on voluntary status, and you say, okay, you know what? I have decided that I want to leave. Well, under Section 12, it's a 3-day notice, meaning the facility's got 3 days to either let you go, or they have to petition the court for a court order, which means you get a hearing, to detain you. In Florida, under the Baker Act, it's actually 48 hours. So you're there on what we call a voluntary admission basis, and you say, listen, I want to leave. Now the facility has 48 hours to do basically one of two things. Either 1, let you go, or 2, they have to file a petition for placement, meaning they are asking for a court order to extend your detention, okay? And at that point, you're going to get a hearing, a right to counsel, all those, sort of due process things that we talk about. And as I read to you in the statute, the facility is going to try and persuade you to revoke your request to leave. And why would you do that? Why would they want you to do that? Well, first of all, if you've got health insurance, this is how they make money, right? I mean, why would they want you to leave when your insurance is paying all the bills, right? Your time there, any group sessions that you're supposed to be attending, medications, all of those things, right? So they don't really want you to leave. And frankly, if they do have to petition the court, now they have to present evidence, they have to present witnesses, and they actually have to go and prove their case. So that's voluntary admission under both Section 12 and the Baker Act. A very hot button topic, especially here in Florida. So I would encourage you to check out the Baker Act videos for more information on that. Anyway, with that said, thanks for tuning in. See you in the next video. Bye-bye.